watching Life in Law with David and Ella Ham. This podcast is for general informational, educational, and entertainment purposes only and is not legal advice. David Ham is a Florida licensed attorney and member of the Florida Bar. Ella Ham is not an attorney and serves as the non-attorney office manager of Ham Law. Listening to or interacting with this podcast does not create an attorney-client relationship, and prior results do not guarantee a similar outcome. This podcast may be considered attorney advertising, and the hiring of a lawyer is an important decision that should not be based solely upon advertisements.
Hello, everybody. Welcome to our fifth episode, our fifth show. Can you believe this is our fifth show, David?
Definitely.
As you know, my name is Ella Marie Ham, and I am the office manager as well as the director of operation of the law offices of David Liam Jr. PA. I am not an attorney. My job is to facilitate the questions that you send out to us, so Mr. Ham, to give his legal and professional advice from the question, guys, of your day-to-day life. So without further ado, let me continue to introduce Mr. David Ham, who happened to be my husband, but also the founder as well as the owner of the law offices of David Liam Jr. PA. Mr. Ham?
Well, thank you for that introduction, Ella. And yes, we do answer your questions here as best we can, to the extent that we can. But our show is more than just a question and answer show.
Exactly.
It is indeed the Life in Law podcast. So as you can probably see, you're seeing a bit different side of our life here in the office than what you've seen before. Today is a day where I'm not in court and not seeing clients today, so we're a bit dressed down versus how we usually appear here in the office. And it's been a very full and busy period for us. So we're happy to let our hair down, so to speak, for a little bit and come to you and answer your questions.
Awesome. The goal is to educate, empower, and help our community to understand an informed decision before they make a decision when it comes to the law. That's the goal.
Indeed.
And then also to let you in our life, our everyday life. So that is the purpose of the show.
And so the topic of today's show is civil litigation,
Civil litigation. We have a lot to talk about. Okay. But before we talk about it, let's talk to the people about our nugget of the day.
That's new, isn't it?
Yes. Hello, everybody.
So what is this nugget of the day?
The nugget of the day is so our listeners, the people, because we are receiving so many people who said they are very interested in the show, they like the show, people who are subscribed to our YouTube, Facebook, TikTok channels. So we're trying to make something for them. So if you listen to the show, throughout the show, we're going to ask a question. The question can be in the middle, beginning, and somewhere between. We're going to ask a question, the nugget of the show. So the first person to call and tell us what was that question and answer will have a $10 gift card from us. The gift card can be for coffee, tea, whatever you prefer. You just have to let us know what your preference. We'll go get the gift card and then we'll go from there. A list of all of the gift cards gonna be in there. So you did have to choose one from the list in your screen. So
sounds interesting.
That will be very interesting. And then I'm putting it as well for our staff because it seems like they are very interested in the show as well.
Well, so speaking of our staff, I'd like to find out from our viewers whether our viewers are interested in meeting and getting to know our staff members in future shows.
Exactly. We've been asking that. So let's see what the viewers say. So every so often we may take one of the staff, one of their favorite cases they like to work on. It can be criminal, personal injury, or other civil litigation with Brent. So we let them talk a little bit about it. So I feel like that would be a good thing. So we're letting you in, guys, in our lives. So please, we open the door. Just come in.
So what is this nugget
this is our fifth episode, like I just mentioned. Are you excited?
Always.
Exactly.
Now, my excitement level is sometimes hard for people to see
To
and
get.
perceive and read. But yes, indeed, I'm
Actually, I
excited.
have to say you're doing a great job. From beginning of the show, you're more relaxed. The beginning, you're just more very serious. It's business, but now you're a bit relaxed. I have to say that you have
Well,
done
maybe
that.
it's the clothes I'm
I
wearing too.
guess, I guess. So let's go to the
They say the
show.
clothes make the man, right?
Exactly. So let's start with the show. So today we're talking about civil litigation that can be collection, business contract dispute. We're gonna talk about it, not personal injury. Like you mentioned, personal injury can be a civil litigation. We have a full show. If you watch the whole episode, the one past, you're gonna hear more about the personal injury. But today is not about personal injury. Today is more about contract, dispute contract, and also about collection. So, without further ado, Mr. Ham, one of the people asked, what is a civil litigation?
That seems like the most logical first question. So, if today's show is about civil litigation, let's describe what is civil litigation. As you mentioned in previous shows, we talked about personal injury, which is a category of civil litigation. But in today's show, we're going to speak more in the areas of disputes between parties that are of a civil nature. That's a good shorthand for identifying civil litigations. Examples include contract disputes, like you mentioned, civil disputes, and also, which falls into the area of civil, family law falls into civil. However, we're not talking about that when we talk about general civil litigation and litigation in the civil area. So, maybe our discussion should begin in the area of contract disputes and understanding how those come about. So,
Yes.
contracts are something that everybody in our society deals with, lives with. Um, we have contracts that are written agreements that are enforceable by the court. We have contracts that are non-written or oral contracts. And so maybe in some of our later questions we'll go into more detail about what those are. But there's a process by which those contracts are formed. There's a question about what the terms are of those particular agreements. And then there's also the course of performance. And then you may end up in something called a breach. So it's a breach of a particular duty or obligation under that contract. And that's what usually results in disputes and ends up with people in court. Now, a lot of these things may be resolved before the dispute arises or before the need to litigate the dispute.
As you can see, we moved. This is we have to move from one page to another. We are currently in our Liberty conference room. As you can see, we moved. Let's go back to the show. We have a lot question to answer. So the next question, Mr. Ham. When should someone consider to hire a civil litigation attorney?
Well, like I've answered in all of the others, the sooner the better. With all of these legal questions, the sooner you get an attorney involved, the better it is.
That's good. That's really, I agree with that. Next question they have. What is the first step after filing a lawsuit? You want to give the answer if they decided to hire an attorney or not.
Well, if the lawsuit has been filed, there should have been a lot to go in prior to filing that lawsuit, especially under the current rules. The new rules require that attorneys have thoroughly investigated the case, that the case has the evidence that's necessary, and that you provide this evidence very soon after filing the lawsuit. So, just from a procedural standpoint, you have to serve the other party. If you're the one that's starting this lawsuit, you're what we call the plaintiff, you have to make sure that you serve the party with the initial documents, a summons, which summons or calls the opposing party into court, and together with that summons, the initial pleading, which is usually a complaint, and it outlines all of the allegations against that party. So, as a brief answer, that's what's going to happen next is that you serve the party. Going a little further into that, you have to get into investigation, collection of evidence, preparing the initial disclosures, and then there's a whole series of other steps that happen all along the way.
In the law firm, we call that discovery, right? Is that
Well,
what you said?
discovery happens after the initial disclosures under the new rules. The new rules require that these initial disclosures happen first, and then that starts a discovery process. So, with the discovery process of collecting the data, collecting all of the information, and sharing the information with the other side, doing interrogatories, the depositions, and requests for admissions, requests for production, all of that happens in the process of discovery. So you think of discovery as information sharing.
Great. The thing of the matter, let's go back to after discovery. So one of the viewer asked one question. Asked, what is the difference between deposition, mediation, and arbitration?
Well, each of those are three things. All they really have in common for the most part is the fact that they end in shun. But arbitration and mediation are forms of alternative dispute resolutions. Those are things that may ultimately resolve the case. A deposition is when you go and answer questions after questions after questions. It's a discovery tool. So deposition relates to discovery. It's a tool of discovery to find out information. And then depositions can also be taken to perpetuate testimony, meaning that if a witness is not expected to be available during trial, these depositions can be taken so that they can be shown or the transcripts read in the event of a trial. So now, what is mediation? Mediation is kind of a conference to see if there can be a resolution or settlement reach. It's looking for a middle ground or some deal to be had between the parties. That's mediation, like middle ground, mediation.
Mediate.
But arbitration is also an alternative dispute resolution where it's basically like a private trial. It's a private court and a private trial. It may be one arbitrator. There may be multiple arbitrators, maybe three arbitrators on a panel. And then it's one of those where the rules are chosen differently, such as AAA arbitration, American Arbitration Association, JAMS, and so forth. Different sets of rules, which in many ways may be similar to those in private litigation, or they may be different. So it's very specific and depends on the scenario.
Okay, great. Great. But so in our office, we have something that we usually do before deposition. We prepare our client with questions. We prepare them with body language. We prepare them with their emotion, what to do and not what to do. One of the things we usually tell them not to do is to never use the word never, never used to say to tell you the truth, to be honest, and always. Those are the words that we make it imperative for our client. I want that time to remove from their vocabulary. Can you please explain to the viewer why we do that?
Okay, so preparing a client for deposition can make a tremendous difference in terms of the experience during a deposition and then the product, what gets produced at the end of that deposition. It's not about coaching the client about what to say
To say.
necessarily, but it's all those things that you mentioned. You want to ensure that the client has composure and maintains their composure throughout that process. There's so much about demeanor, there's so much about body language, there's so much about things that we normally would not think about in other contexts. And because it's an experience that most people don't have of providing their deposition, and so I think it's a good time to further define what a deposition is. So the attorneys in the case may request a deposition in which the client or the deponent has to appear, raise their right hand, and under oath answer all of the questions that are raised. Now, the number of objections that can be brought by the attorney who attends the deposition with you is extremely limited. In fact, in federal court, it's only a matter of privilege that, or an objection as to form. Basically, two sets of objections that can be brought in federal cases. And then you see Florida is moving very much towards the federal standard and adapting that. And so these objections and speaking objections, things that used to be done in the past, are all being rooted out now. And so your attorney basically has to be a potted plant during that deposition process. And all of this information is being brought out. So we want to get prepared, thoroughly prepared. Ours is a firm that goes that extra mile of preparing beforehand so that you're comfortable and that you can give effective testimony during your deposition and not waste anybody's time.
Exactly. So one of the things we do, there's a book currently we are reading that's talk about the power of the silence. That's our so the power of emotion, the power of what emotion can do. I have to say that a lot of our civil cases, really what hurt the case the most, I would say, is emotion. Can you elaborate a little bit about emotion in the lawsuits?
Certainly. So we talked about it a bit in our episode on family law and how emotional decisions often are the wrong decisions, or when they're impulsive and not thought through, they can have bad results. And so the same is true in litigation. The same is true when being deposed, that you want to stop, take your time, think about the question you're being asked, and then respond. You only are able to respond after you've given thought. If you're immediately providing an answer or immediately reacting, you're just reacting, you're doing just that. So we don't want to be reactive, we want to be responsive. And so that's how we prepare our clients to be responsive during depositions and not merely reactive.
So in our
We have
office,
so many
question. It seems like we're gonna have a part two of of the litigation because we have not even penetrated the surface of those questions. So let's go to the next question. You really explain deposition for people, and then we're probably gonna have to have a show in deposition.
We sure can.
For people we have so many questions. Deposition. The nugget of the day is
The nugget of the day?
the nugget of the day.
The nugget of the day.
The
Everybody,
nugget
hope
of
you're
the
listening.
day. The nugget of the day is gonna be the question they ask: how old you have to be in the state of Florida for a contract, for you to be under contract, and for contract to be binding?
Okay, so if the question is about contracts made by minors, this is not exactly a simple question, because certain contracts made by minors for essentials, food, etc., can be enforced because they were essentials and the minor had to have them. Now, other contracts made by minors would be void unless they were an emancipated minor or something like that. And they can be voided, say, if a minor purchased a car, something of that nature, and didn't have the authority from their parents. You have to be careful. Car salespeople out there, if even though they have their driver's license, they're
But
16,
how old you have
16
to
years
be?
old, what have you, but if they're not 18, then the parent can come back and have that contract made with that 16-year-old voided. So
You have to
18
be
is
18.
the age of majority in the state of Florida. So it's not, I don't think that there's a simple one word answer to that of 18 years of age, but because certain contracts of a minor can still be enforced.
Okay. The next that was the nugget question. Okay. So
We have a nugget answer. So I guess 18 would be
the
the
answer.
age of majority and the age to contract in the state of Florida. However, just understand a lot of laws that way. There's a however, certain contracts can still be enforced if they were made by a minor.
Okay. When can a business legally pursue someone for an unpaid debt, and what document is necessary for them to prove the debt?
Okay, so now you're getting into a specific type of dispute that we
Which is
generally
collection.
refer to as collections. So
For people
if the
to understand
question
what is
is
it.
about just a debt generally, there is a cause of action which is called debt, and so you would sue for a debt. And then the question becomes is what is the evidence of that debt? That's what gets presented in court. If it's a written contract, yes, the contract and terms of that contract will be interpreted, and that's what will prevail.
Okay, so the contract and most of the debt, the contract has to be one of the proof for the to validate the debt, right? If I understand.
The contract is the most powerful and most prevalent form of being able to prove the debt. If you don't have a written contract with the person, there may be other evidence to establish what the debt is. Say, for example, uh, bank statements and in the circumstances. If you provided the funds for someone to obtain something and there was no um, relationship between the two of you to explain why you did it, you may be able to recover that as a debt because you did it expecting a return. You, when you prove that expectancy of return, this is why we have lawsuits. This is why we have litigation, is to be able to present the proof that establishes the claim that you bring. So this applies to debt collection as well as to every other type of claim. You make the legal claim, you present the proof, and then you get the judgment.
Okay, last. So the
If the
next
question
question
is,
people ask is gonna be about a business and contract dispute. We're gonna go to the next question. They said, can what make a contract legally binding and legally enforcing, and can a verbal contract be a legal binding contract?
well, let's take those one at a time. So, what this goes back to our original conversation about what is a contract. So, with the contract, there has to be offer and acceptance. This is something called mutual assent. And so, the offer and the acceptance can occur through writing, or it can also occur through spoken language. So we can have oral agreements just as well as you can have written agreements. And the legal enforceability of them may depend on what is the object of that agreement. Certain oral contracts are not legally enforceable because they have to be in writing. For example, contracts that are going to purport to convey land. So if it's about selling land in Florida, that's going to have to be in writing. And then there are other contracts which are required by law to be in writing. But outside of that, you can have oral contracts, and they can be enforced by the court. Now, I think part of the question you asked had to do with the formation of those contracts, and this is an entire course in law school. In fact, it's a course that in my law school was in two separate semesters. So obviously, we don't have two semesters
To answer this question.
to answer that question. But just understand, yes, there can be contracts both oral and in writing, and they can form through conduct as well as through what's either written or spoken. And so, and yes, depending upon how this all plays out, the court may enforce it or may not enforce it, and that's why contract lawyers are generally paid so well and why there are courts to resolve these disputes.
So the other question is that can a business protect? How can a business protect themselves before signing a contract? I know the answer, but can you
You know the answer?
hire an attorney?
That's a great answer. I like it a lot. But peeling back a little layer on that, which may involve hiring an attorney and probably should hire an attorney, is, whether at the beginning, as you're beginning to do business with another business or with other people, if you, in the planning stages, involve an attorney and work out what could go wrong and how to make things go right, then at the drafting stage, you can draft well-written agreements that should uphold in court. But there still will often be disputes, and that's the point where we as litigators would get involved, either defending your position or being on the offensive for you.
So the next question, fire questions.
Okay.
So, writing contract or handshake?
A written contract.
Mediation or trial?
Well, mediation, if you want to get to the resolution sooner.
Email or text? Which one is the strongest evidence?
I would say email because it has the to and from information and some other metadata if you're lucky.
Okay. Biggest mistake after a lawsuit?
Ignoring it.
Can social media hurt your lawsuit?
Definitely.
What is the biggest misconception about civil litigation?
That it's easy.
Settle or trial?
The advantage of a settlement is that you're certain that you're going to get payment. If you try the case, you can get the verdict in your favor, but you may be stuck in appeal for a long time, and the other party still might not pay. So I'm going to go with settlement.
Okay, good. That's good. So we got another twist to it now. We're going to go to myth or fact.
Fact or myth?
Yes.
Myth or fact?
Yes. Verbal contract is never enforceable.
Myth.
Can you sue for any amount of money?
Myth.
Really?
I think that's a myth.
Okay. Winning a judgment mean you automatically get paid.
Also a myth. Are these all myths?
Ignoring a lawsuit make it go away.
That's definitely a myth.
Every case go to trial.
That has to be a myth.
A demand letter can prevent litigation.
Prevent litigation? Oh, that's definitely a myth.
Okay? Social media can be used as evidence.
That's a fact.
Okay, so not all of the questions are
Well,
met.
it's a fact if certain rules are met, yes.
But let me ask you, different that. Can social media hurt your case?
Certainly.
Can you elaborate a little bit on that?
Well, just think about it. The information that's placed there is generally voluntarily placed, and often what's found is something that's very damning. So it's almost obviously hurts in many cases.
I agree. So, we want to say thank you to all of our viewers. This is the end of the show. We want to say thank you to you guys for taking your time to watch the show. And then we want to take the time to wish everybody a happy July 4th. Happy Independence Day to all of the American and all of the people who are living in America. Happy Independence Day. And thank you for watching. Until next time, we appreciate it. Happy